Welcome back to the Making International video series. In this video, I'm going to explain the event subsequent to the 1951 San Francisco Peace Treaty. Because the textual clause of the peace treaty makes no mention of Dokdo, the event that followed in the years after its signing are not interpretive evidence under Article 32 and 33 of the Vienna Convention on the Law of the Treaties. But these subsequent events are still of interest with regard to Dokdo's sovereignty and the decisive and consistent actions taken by Korea to consolidate its possessions. Dokdo certainly supports Korea's claim of sovereignty over these islands. The status of Dokdo remained controversial after the peace treaty was signed in September 1951. 5 months later, January 18, 1952, then Korea President Lee Seung-man issued a presidential proclamation that created the so-called peace line, a territorial boundary averaging 60 miles off the coast of Korea, which explicitly identified Dokdo as a Korea territory. Japan protested this peace line and declared that it did not recognize Korea's claim to Dokdo. Several months later, Japan issued a tacit protest to the U.S.-Japan Security Treaty, which has designated Dokdo as an area for U.S. military training. After receiving a similar protest from the Korean government, the U.S. military announced on the 1953 February 27 that Dokdo would be excluded from its training area. The United States sought to avoid any direct involvement in this issue, but did publicize the letter which made August 10 of 1951, which is a note to the Korean ambassador in Washington, D.C., when the question was raised in 1953, and stated then that we have publicly declared our view that this island belonging to Japan, but no one in Japan or elsewhere seriously expects the United States to take military action under the U.S.-Japan Security Treaty to reclaim this island for Japan. In May 1954, the citizens of both Japan and Korea, under the protection of patrol boats from their respective governments, landed on Dokdo and proceeded to erect signs declaiming sovereignty while dismantling the sign erected by the other nation. Korea physically possesses Dokdo and rejects Japan's International Court of Justice proposal and normalized relations with Japan in the 1965 treaty is the key history of the recent period about the Dokdo. After Korea erected the lighthouse on Dokdo in August 1954, the nature of the situation changed. With Korea physically possessing the island, Japan increased its mode of protest and in September 1954 proposed that the matter be submitted to the authoritative International Court of Justice, but Korea rejected this proposal. Between 1952 and 1960, Japan sent 24 notes to Korea on the Dokdo matter, and Korea responded with 18 notes back to Japan. The matter was also raised again through diplomatic channels during the protracted negotiations that led to the signing of the 1965 Korea-Japan Treaty, but because of the Korean resistance on this issue, from 1957, when the talks were resumed until the signing in 1965, the Dokdo problem was never adopted as an official agenda item to be recorded in the minute. There is absolutely no direct reference to Dokdo in the various documents of the Korea-Japan Treaty signed in 1965. Originally, Japan thought of writing down the problem in the treaty or failing that as planned in advance, and the instrument to be exchanged agreeing to take the case to the ICJ. However, the Korean side rejected both plans by arguing that Dokdo could not become an agenda item as it was Korea's inherent territory. Korean Ambassador Oh Jae-hye, who was involved in these negotiations, explained that on the day scheduled for the signing of the 1965 Normalization Treaty, Japan opposed language to be inserted in the dispute resolution protocol that would say disputes such as Dokdo Takeshima shall be resolved through a conciliation procedure. The Korean negotiator refused to consider this insertion. After a cold hour has passed, the Japan's prime minister agreed to take out the reference to Dokdo, and the treaty was then signed. According to Japanese view of negotiations, the general language that remain in the agreement covering all disputes, which say that they are to be resolved through arbitration in accordance with the procedure agreeable to both countries, preserve their position on Dokdo. But Korea has rejected the idea that Dokdo is covered by this side agreement, referring to this notion as a far-fetched construction of the instruments, with Korean Foreign Minister Lee Dong-won stating that since Dokdo Takeshima was not an objective dispute, it could not be covered by the exchange in documents. Korea's position has always been that Dokdo is inherent in Korean territory, and thus the island cannot be viewed as an issue either in the treaty or before the ICJ. Since 1965, in the decades that followed in the Normalization Treaty, Korea and Japan sought to avoid this controversial issue of Dokdo, with each side maintaining its own position on the matter. Japan stepped up its rhetoric in the mid-1990s, claiming an exclusive economic zone in 1996 and asserting its claim to Dokdo, and repeatedly. In 1999, Korea-Japan established a provisional fishing zone in East Sea, which included Dokdo, but this agreement was unpopular in Korea, and the Korean government has unilaterally refused to promote the joint regulatory measure that had been agreed upon. On 26 February 2005, Japan's Shimane Prefecture promulgated so-called Takeshima Day, further exacerbating relations between two countries. But Korea's possession of Dokdo has continued and has been unchallenged except through verbal protest. This long period of the effective occupation, especially when occupied with Korea's strong historical claim to Dokdo, provided substantial support for Korea's claim of sovereignty over this island. Article 32 of Vienna Convention of Treaties discourages the use of negotiating history of a treaty to provide meaning to the treaty, unless the treaty language leaves the meaning ambiguous or obscure, or the lead to a result which is manifestly absurd or unreasonable. But Article 31 allows evidence of subsequent actions or agreements of parties to be examined to provide guidance regarding the understanding of treaty terms. Relevant subsequent activity would seem to include the actions of Korea in gaining possession of Dokdo by 1954, the protest of Japan since then, and the event surrounding 1965 Normalization Treaty. The consistent approach of the ICJ and other international tribunals examining sovereignty dispute has been to focus on the demonstration of effective control, particularly in the past centuries. Korea's possession since the early 1950s would provide substantial support for Korea's claim to sovereignty of Dokdo. Japan's protests provide some support for Japan's claim, but a tribunal adjudicating this matter would have to determine whether they are adequate. Japan's willingness to enter into the 1965 normalization treaty with Korea without any reference to Dokdo would serve to undercut Japan's claim and could be viewed as having acquiesced to Korea's sovereignty, particularly if the tribunal were to contrast this action by Japan with its refusal to normalize relations with Russia until the Northern Territory dispute is resolved. The formal rules of interpretation found in Articles 31-32 of the Vienna Convention on the Law of the Treaties thus appears to support Korea's position on Dokdo. The 1951 San Francisco Peace Treaty makes no mention of Dokdo, and so all interest tribunal would likely take on face value and conclude that the peace treaty has no relevance to Dokdo. If, on the other hand, the tribunal were to conclude that the peace treaty failed to mention Dokdo create an ambiguity, then tribunal could examine the drafting history, in which case it would find further ambiguity in the conflicting drafts and notes pointing in different directions. Perhaps the most important pre-1951 document is the Scapin number 677, which separates Dokdo from Japan, as well as Scapin number 1778, authorizing bombing operations in and around the island. As one Korean scholar has explained, because Scapin 677 specified that Dokdo was Korean territory, the Treaty of Peace of Japan would have to explicitly overturn this stipulation in order to supersede the original designation. If a tribunal were then to look at the subsequent events, as it is authorized to do under Article 31 of the Vienna Convention Law of the Treaties, it would probably focus on the actual Korean occupation of Dokdo and the Japanese acceptance of the 1965 Normalization Treaty without any reference to Dokdo, both of which provide support for Korea's position. Japan's protests are not irrelevant, but they would probably not be viewed as sufficient to overcome the acquiescence evidenced by the 1965 treaty and Korea's continued occupation of the island.